Good morning. Today, an important judgment I would like to discuss with you was you would have gone to petrol bunk to fill up your fuels several times, but whether I do not know whether you have noticed that the petrol bunks are having vapor recovery devices or not. So actually, uh, one person seems to have gone to National Green Tribune complaining about that the petrol bunk is not having vapor uh, recovery system mechanism. Therefore, the Green Tribunal has given direction restraining respondent 5 to 9 from commissioning or operating any new petroleum retail outlets in Tamil Nadu without installing vapor recovery system. Stage 1 and 2 in good conditions, pending disposal of the. Then thereafter, they seems to have finally they have discussed about the necessity of this vapor recovery system and passed the order. Against that, they seem to have gone to Supreme Court, challenging the jurisdiction of the Supreme Court. So Supreme Court has held that Tribunal had directed Central Pollution Control Board as well as State Pollution Control Board to make mandatory for new as well as existing retail petroleum outlets to obtain consent to establish and the consent to operate tribunal. Tribunal had power and jurisdiction issue impugn direction. This is what this NGT Act was to protect and enforce any legal right relating to environment. The next question is most important. They say air prevention and control of pollution, issuance of directs. Due to non-installation of VRS in petroleum outlet, Tribunal directed to make mandatory. Therefore, they say green fuels are under green category. They say CPCB after due consideration deliberation guidelines classified automobile fuel outlets under green category, thereby exempting them from consent management. Impugn direction being unreasonable, causing hardship and time consuming was set aside. However, CB was required to ensure that direction issued by tribunal is complied with, otherwise to bear legal consequences. So this is a good case. You can go and if you find any petroleum outlets are not having this device, you can approach Green Tribunal for contempt or to take appropriate action. Initially, you have to lodge a complaint to Pollution Control Board and see how to file cases with Pollution Control Board. You must first precisely impute the what pollution, by what air pollution, sound pollution, water pollution you are being affected or the public at large are being affected. Then you befit that imputation with a particular act and find out under which violation that imputation of pollution is coming. Thereafter you will issue a notice to, because notice is mandatory, you can issue notice to or file complaint before the Pollution Control Board. Then thereafter you can approach National Green Tribunal. This is the way you have to do. Then question arises, what are the other topics which you have to understand so as to write your examination. Novelty of contract. Novelty of contract means if once a contract is entered into and subsequently they have amended or altered certain conditions or extended certain conditions, that is called novelty of contract. So that subject, that topic should also be understood by you. Then question arises, now recently the powers of governor and powers of president. See, this is that what the other day I said is a democratic republic. So whether there are absolutely lot of powers given to president as well as governor, so far the activities of the respective union and the state governments are concerned. But everybody wants these two head of the sovereignty of the state as well as union be remain as a rubber stamp. And since we have crossed independence and Republic Day for more than 5 to 6 decades, absolutely the Indians who born after independence, after Republican, may think differently, and the governors are being appointed also thinking differently. Here you cannot, once you are being elected, and you cannot act according to your whims and fancies and pass some orders, create some chores or favor something. And this is what the present governor of Tamil Nadu intervenes, whether that constitutionally valid or not, whether the constitution should be rewritten or not. It's $1,000 question. I don't think that constitution should be rewritten. It is far better that India, comprised of multi-number of states, must have the presidential form of government will be better instead of this Tuklak cabinet system of the ministers. Once they are only advisors, but they are acting as a dictators, and they want the governor should also bow before them and comply their orders. Here, why the chief ministers suggested for allowing the minister to continue without portfolio? What is the use if he is being paid from the exchequer for whether he is expecting that salary or not, whether he is that salary will be too remote as a tips for his other incomes. But why he should be there? You remove him from the ministership for time being, and subsequently if anything happens, you re-induct him. What happens? Is there not any other valid or competent man in their MLA strength? Then why should they particularly favor this Balaji? Another thing was the division bench has stated 3 things they have stated. Number 1, they maintain the writ of habeas corpus even though remand is legally passed and competently subsequently vouched by the principal session judge of the concerned court. And still they say whether the mandatory requirement at the time of arrest is followed or not, they are going to look into. So if that is the concept and that is the procedure which the High Court wanted to look into, I don't think at least 1 lakh cases be filed before the said division bench for having such grievances, multi-number of grievances of violation of these statutory compilation as well as fundamental rights compilation, constitutional compilations required for the arrested persons being followed. So all these things are done. Another thing is allowing a private hospital to look into the ailment. So that will also multi-number of cases the courts have disheard the prayer of the detainees, prisoners when they approach the Honorable High Court under habeas corpus. But this time they are lenient for what? For whom? Is this the democratic system? This is equality and equal protection before law? I don't think there will be an answer for all those things. I understand the anxiety and the curiosity of the judiciary coming to rescue of the minister, because he is a minister and a powerful minister, financially more powerful minister. They are giving some concessional privileges to have access to the judicial review in the legally statutory remanded accused. It's all right. There is an apex court to look into over that. I take leave. Best wishes.